Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone that's here in Carson City, as well as those in Las Vegas, and of course, anyone viewing online through YouTube or Nellis. With that, Committee Secretary, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Urick, Chair Miller.
Here, and Vice Chair Marzola is here. I think she just stepped out for another second, so please mark her present. With that, just a few reminders, asking everyone to please turn down their electronics. Also, as I'm doing myself every morning, as I remind myself. Also, today's meeting ID for those participating over the phone number is 888-475-4499. And the meeting ID for today is 867-267-78973. Thank you for turning down your electronics. You can also find this number posted on the agenda on Nellis. With that, we do have two bills today. We will hear the bills in order. We also will have public comment at the end of today's meeting. I ask that presenters keep their bill presentations to 15 minutes each, and that anyone testifying on a bill or making public comment keep their testimony to 2 minutes each. Of course, the first time you speak, we ask that you state your name and spell it so that we have it correct for the record. And if you belong to any affiliation, to please state that affiliation as well. When you're testifying, we ask that if there's more than one person at the table, that you state your name before each time you speak. That way, it's correct in the minutes. With that, we do have two bills, and we do need to be on the floor at 11:30 a.m. today. So with that, that means that I will be taking for each bill 20 minutes of support testimony, 20 minutes of neutral testimony, and 20 minutes of opposition testimony. Also, members, we will have one round of questions, and just want to remind everyone that a follow-up is a follow-up for additional clarity to that first question. It is not a second question. And with that, we will go ahead and begin. I will open up the hearing for Assembly Bill 201. Assembly Bill 201 revises provisions relating to the sealing of records for summary evictions. Assembly member, I'll give you a few moments to get settled, and whenever you and your co-presenters are ready, please proceed.
Good morning, Chair Miller and fellow members of the Assembly Judiciary Committee. My name is Erica Roth, E-R-I-C-A-R-O-T-H, and I'm proud to represent Assembly District 24 in Washoe County. Thank you for the opportunity to present AB 201, which seeks to expand the circumstances under which a summary eviction is automatically sealed. Today, I'm joined by Jonathan Norman, Policy Director for the Nevada Coalition of Legal Service Providers, and present in Las Vegas is Nick Haley, an attorney with the Legal Aid Center of Southern Nevada. An eviction record creates significant barriers for individuals and families seeking housing. These records can negatively impact credit scores, making it difficult to secure rental housing, employment, and even access to loans. The consequences of an eviction can be far-reaching and long-lasting. Even when the outcome of an eviction favors a tenant, a single eviction record can severely limit a person's ability to find safe and affordable housing, trapping them in a cycle of homelessness or substandard living conditions. While eviction records can affect all tenants, studies have shown that communities of color are particularly susceptible to this practice, and women with children are especially vulnerable. During my time as a legal aid attorney, I witnessed firsthand the devastating impact this housing crisis inflicted on some of our most vulnerable neighbors. Seniors living on a fixed income and parents just trying to keep a roof over their heads of the families and unsure of how to navigate a complex and often onerous legal system. This body recognized the barrier eviction records pose to addressing this crisis, and Nevada law allows tenants who are legally evicted to ask a judge to seal the record. This means the eviction will not be searchable or publicly available, providing tenants with a measure of protection against bias when seeking housing. Assembly Bill 201 seeks to mitigate these negative consequences by expanding access to eviction record sealing. The bill builds upon a current existing Nevada law, which already provides for the automatic sealing of certain eviction court cases, by creating additional pathways for tenants to have their eviction records sealed. With the chair's permission, I will now hand it over to my co-presenters to provide a more in-depth overview of the bill.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. So our presentation will be two parts. Mr. Haley down in Las Vegas will give you just a brief synopsis of where record sealing sits today, and then we'll walk you through the bill. And then I will address just a few things that have come up with stakeholders that are changes we anticipate to make for the bill. We don't have an amendment today, but I think it could head off some of the questions that we might get. So I think that would be a good use of time. Thank you.
So with that, I would just like to clarify, you will be presenting the bill based on what you will submit as a conceptual amendment?
Chair Miller, Mr. Haley will walk through the bill as it exists before the committee today. And then there's just a couple things that in discussions with stakeholders yesterday, I think we will be bringing forward an amendment in the coming days, but I think there could be questions about some of those things, so I feel like addressing them head on will get us through that.
Sure. So if you could, when you get to those areas, if you could, even if you don't have the exact amendment that you plan to submit, if you could at least identify the area that you plan to adjust, I think that would be helpful for us.
Jonathan Norman for the record, absolutely.
Thank you so much.
And with that, I'll turn it over to Mr. Haley.
There we have it. Committee members, can you hear me now?
Yes, we can. Proceed. Thank you.
Thank you. Nicholas Haley. I represent Legal Aid Center of Southern Nevada. I am a staff attorney focused on eviction and housing.
Mr. Haley, could you spell your name, please?
Yes. First name Nicholas. Last name Haley, Haley. The current status of eviction sealing law in Nevada is there are three broad categories under which an eviction may be sealed and one general category. The specific categories are anytime an eviction case ends in a dismissal or a denial, the case is subject to automatic sealing. In addition, should the parties to the eviction, that is the landlord and tenant, stipulate to the sealing of the eviction, it is also ripe to be granted to be sealed. There is a broad category of interests of justice in which the court is entitled to weigh the benefits of sealing versus the interest of the public to deny sealing of an eviction. So there are four categories altogether under which an eviction may be sealed. Three that are generally automatic, well, two that are generally automatic, one that is stipulated, and one that typically comes on a balancing of interests. What we have in the bill today are some modifications to that, which would create a motion by the tenant whereby there is no opposition from the landlord. This is a circumstance that arises frequently where tenants and landlords change hands frequently, properties change hands. Oftentimes, the landlord has no interest in pursuing the eviction further, and there's no participation. And thus, in cases where the landlord is reached but has no interest in responding, this would grant an automatic sealing of the eviction. Going down the bill to sub E, you see that there is some language that addresses circumstances whereby a case is taken up on appeal. This is a circumstance where a tenant would have appealed their summary eviction and they were granted relief by the appeals court. Typically, a case that is appealed goes before a district court. It does not ordinarily go before the Supreme Court or the Court of Appeals. Almost always the cases go before a district court where it has a terminal resolution. That is, the resolution at the district court level is the end of the appeals process. What this change would do would make it to where a decision which dismisses or denies the underlying case would also be subject to automatic sealing. And this is something we would find consistent with when the decision was granted in the initial hearing. So this would just make it consistent with what we would get from a dismissal or denial should the case have been granted that relief without the appeal. One note I would make regarding this that is not the state of the bill you see is that currently the appeal case is not itself sealed. And I need to explain this. When an eviction case goes before an appeal and a decision favorable to the tenant results, the underlying case, that is the case before the justice court, can be sealed and typically is sealed currently. What is not sealed is the district court case. I just want to make that distinction because the way it's currently worded, I don't think addresses that directly. So I just wanted to point that out. And then finally, on page 3 of our bill, we have under sub 2, number 3, we have an amendment that would create a presumption that sealing the eviction is in the interest of justice if the eviction is more than 1 year old. So this is a case where an eviction is granted, a year has passed, the person applies for a sealing of the eviction, and the case is now more than a year old. There's a presumption this would create that would make it to where this would favor sealing the eviction case court file.
And Chair Miller, I'm Jonathan Norman for the record. I'm just going to jump in. So when Nick said the amendment, he meant the bill, which amends the law, not an amendment. So just to clarify that. So
correct.
If we think about this bill, we're doing 3 things, right? One, we're saying when a tenant motions for a record to be sealed, and the landlord does not oppose that motion, then the court shall grant the sealing, right? So when a party doesn't respond, we get a default. Number 2, we're expanding that when there is an appeal to the district court, when the appeal is to the district court and the tenant prevails in the district court, that the record shall be sealed because they've won and they shouldn't have the kind of scarlet letter of an eviction. And number 3, after 1 year from the entry of the order of the eviction, there is a presumption that the record should be sealed and that that's in the interest of justice. So those are the 3 things the bill does right now. And then the things that and now I'm going to switch to what we're talking about prospectively, and we'll likely have an amendment next week just to head off any questions. Nick mentioned in Section 1, subsection C, that these cases have a terminal jurisdiction in district court. So we would be amending to eliminate the Court of Appeals and the Supreme Court of Nevada. There's a couple logical reasons for that. Those courts are setting precedent. The interest of justice, the interest of the public in knowing would almost always be outweighed. I don't think it's appropriate to have those 2 courts in there. And then adding to automatic sealing when the landlord does an illegal lockout. That makes sense because it's an illegal lockout when the landlord acted without proper authority, so that record should be sealed. And to take away the discretion there, so it would be automatic, similar to when the tenant prevails. And then finally, in Section 1, subsection 2B, the courts pointed out that there needs to be a timeline for the landlord to file a response, because without a timeline, the court will have to hold a hearing, which will waste judicial resources. So we will, I don't think we've landed on a number. Typically in landlord-tenant law, 7 judicial days is a number we hear a lot. So we'll likely have an amendment just to cap that timeline so we don't have courts feeling like they have to hold a hearing and slowing processes down. And with that is the bill as it stands today, 3 things that it's doing, and the kind of refinements I think we need to make as we move forward. And with that, I think we're ready for questions.
Okay, thank you so much. And I appreciate the fact, I mean, generally our expectation is that people come with their conceptual amendments, but I know that oftentimes bills get worked on into the wee hours of the night and after the hearing and so on. So I appreciate your commitment to continue to work on this possible measure. With that, we will begin questions. Our first question will be from Assemblymember Hardy.
Thank you, Chair. Good morning. And my question is just following up on the last thing you mentioned there regarding the landlord not opposing the motion. So if you could just kind of give a little more detail. You did mention that you would put in a response time, number of days. But what does that just look like so that it's clear on the record? A landlord response, is that they're notified of the motion, then they can, provide an answer. Just what's that process so that we're not just saying, oh, we hope that the landlord knows that the tenant's sinking this ceiling.
Thank you for the question, Jonathan Norman, for the record. So this will be a motion filed into an open case, and so there will be e-service as motions are done in existing cases. And in addition, there would be a mailed notice, and then a certificate of service would be filed with the court. And so then the landlord would have, we got to land the timeline, right? But I think 7 judicial days is something we see in landlord-tenant law to then file the response.
Thank you so much. Our next question is from Assemblymember Gray.
Good morning. So looking at the other side, if there's going to be a presumption after 1 year that the record's going to be sealed, could there be something that would actually protect the landlord's interest? Say if there were still monies owed, if it was a lawful eviction and they were evicted, and the landlord has not been made whole yet, could there be a presumption of that will not be sealed until the landlord's made whole?
Jonathan Norman, for the record. Thank you for the question. Eviction court does not deal with money. It deals with possession of the property. And we would, if a tenant has not paid their rent, just a policy perspective, if a tenant has not paid their rent, there can be a lot of reasons, right? So you could have a bad acting tenant that's trying to get one over on the landlord, right? However, since the pandemic, we've seen historic rises in rents. I think we had 25% from the beginning of the pandemic till the end, and then rents have continued to rise. I did see one report that they cooled by 1%. And then you have tenants being squeezed by other issues like inflation. So not paying your rent and getting evicted because of economic forces should not bar you forever from entering the rental market. We set 1 year as a timeline for when somebody could file a motion. The landlord can oppose it, and they would have to overcome that presumption, but it does not contemplate a situation where that would hinge on whether rent is owed.
Thank you.
I'm so
continue.
sorry, Chair. Erica Roth for the record. I'm just going to jump in on that. I think it's important to remember that this would not preclude any civil actions against tenants. But I don't want it to be lost, the real human lives that we're dealing with who are trying to get back on their feet and make sure that, they're able to care for their families and keep their kids in a home. And so when we're talking about record sealing, presumptions for record sealing after a period of time has passed, it's really about ensuring that our communities are safer, that our families are being taken care of, and that they are able to get back on their feet.
Thank you for that. Our next question is from Assemblymember Gonzalez.
Thank you so much, Chair, and thank you so much for the presentation. Assemblymember, I just want to piggyback off of that. Can you talk about why this is important and the impact that this has on people who are experiencing this, please?
Yes, Erica Roth for the record. Thank you so much for that question, Chair, through you to Assemblymember Gonzalez.
Please go direct.
Thank you. There's a few things that I want to touch on. First, when we're talking about record sealing on appeal. This is really about expanding what this body has already deemed to be very important policy work, and that is where someone has been unlawfully evicted and a court determines that they have been unlawfully evicted, then they shouldn't have to face those very real barriers to get back on their feet and to get housed. And the reason that that is not just important for tenants, but for our communities is that we are in a housing crisis, period. We are facing record numbers of people experiencing homelessness. We are facing families who are on the verge of evictions every single month. And so anything that we can do to ensure that after they experience one of the most traumatic things that a family can go through, that they are able to rebuild and get back into a home for a stable living situation for them, for their families, for the kids in our communities. Ensuring that people housed is a matter of public safety. It keeps our communities healthier. It makes sure that our schools operate better because our schools are not picking up the slack for the trauma that is happening at home as a result of living in an unstable housing market. And so, this is just one step in ensuring that the kids in our communities, the moms in our communities, the families in our communities are able to really live and thrive in our communities and not just stay in survival mode.
And Jonathan Norman for the record. And I think it's important to recognize that an eviction is a moment, but the consequences are years and years. And, when someone's evicted, they're likely going to be doubling up with other family or homeless or potentially renting at a weekly in our community. And Assemblymember Roth talked about kids. Kids have stability with their school, especially kids who are living in or close to poverty, and an eviction uproots kids and families from that neighborhood, from the babysitter that they had in the apartment complex, from the teacher that they had. And so this bill allows, after 1 year, we're saying that we're clearing the deck, and landlords can still evaluate that tenant based on their current income and all the things that are more indicative of whether they can pay their rent going forward, because their job situation could have changed, circumstances could have changed if they were evicted because they had a sudden medical emergency or a car breaks down and they have an unexpected financial expense. That happening a year ago does not bear on whether they can pay their rent today. So that's what this bill seeks to move those families beyond. Thank you.
Thank you.
Nicholas Haley in Southern Nevada.
Please proceed.
If I may add a couple of notes to what Mr. Norman said. As somebody who sees tenants who face eviction every day, the restriction caused by eviction sealing is considerable. This reduces the available housing to an individual by more than 90%. It is almost impossible to find housing once you have an eviction. A person would have to turn to somebody who does not screen for evictions, and those are very rare instances. So this would greatly open up the opportunities for a lot of people to find housing again. I would also like to note, as Jonathan pointed out, that not all evictions are, well, for lack of a better word, something that the tenant did wrong. There's a number of instances we have where a person suffered a medical episode or an injury, and this one instance in their life just caused them to lose their housing, lose their credit, and suffer an eviction. I would also note that currently evictions purge after about 6 years, so this is a considerable limitation on a person's ability to find housing.
Thank you for that. Our next question is from Assemblymember Cole.
Thank you, Chair. Thank you very much for the presentation. My question is, and I don't know how often this would actually be the situation, but I imagine that there are some tenants out there that get evicted not just one time. It's not just that one-time occurrence. So would you be willing to consider doing a limit where no more than 2 times could the record be sealed in a space of, say, 5 years? I think that's fairly reasonable, just because landlords do need to be understanding and know that there's a tenant that has a very bad record? Thank you.
Jonathan Norman, for the record. So if a tenant has multiple evictions within like a 5-year span, this might not be, I think we're always open to talking about how to improve the bill, but one thing it kind of reminds me of is we have, and I know Nick has had a client who in a space of 1.5 years faced 9 evictions from the same landlord. So 8 of those evictions at least were evictions that did not go through. And landlords routinely, I don't want to call it serial filing, but they will file multiple evictions within the same month, because if a tenant misses one answer, they are evicted. So if I get served 3 evictions in 1 month, one for, let's say, non-payment, one they tack on a nuisance, one for a lease violation. If I miss one answer, I get evicted. And that's not a perfect analogy, right? Because you're talking about a problem tenant over time. I think, in my mind, the piece that remedies that is having the ability of the landlord to oppose, and not only if they have a tenant that they know has been a serial bad tenant, they can come and oppose the sealing of that record. I'd be open to language, talking through language, especially around the 1-year presumption. If there is a serial bad tenant, I would worry, how would you know, right? Because the initial record is sealed, hopefully, if they have done their year and they're renting. And I would say landlords, the best thing for the landlords to do is to be evaluating that tenant based on their income at the time they're renting and their resources at that time.
Erica Roth, for the record, and thank you so much for that question, Assembly Member. I will just tack on to this and add that, I think that as it currently stands and with this bill, with the language of the bill as it stands, is that there is very equal footing for tenants and landlords when you're kind of thinking about that situation. As the law stands, a landlord is not legally prohibited from being a quote-unquote serial eviction filer, right? And so this puts them, quite frankly, on equal footing. I am happy to look at language, but it would need to address both situations.
Thank you. Our next question is from Assembly Member Nadeem.
Thank you so much, Madam Chair, and thank you for the presentation and bringing this important topic forward. So my question is that without the record sealing, how much difficult it is for a tenant to rent a house, and how this bill is gonna help them?
Jonathan Norman, for the record. Thank you for the question. I think it's almost impossible for a family who, if you face an eviction, let's say today, reasonably, when can you be back in like the normal rental market? I would say it's years and years. I think you're going to be doubling up. You're going to be renting from maybe in more precarious rental arrangements, whether that's a weekly or you're renting rooms in a home with other people living there. So I think it is devastating, and I think it's years. And I don't know if Mr. Haley tracks any of his clients beyond the eviction. I know he's turning cases very fast, but he may have something to add there. But thank you for the question.
Thank you.
Yes, Nicholas Haley for the record. Regarding the question, we have a subset of our population in Nevada who, after an eviction, cannot find ordinary housing. I believe I mentioned earlier, it limits your housing options by easily more than 90%. Frequently, following an eviction, we will see people who have to find what are called second chance housing options. The thing is, even those options are becoming more and more limited because so many people are seeking those, to where even the fact that they exist doesn't mean that there's any availability. And I think for a lot of people, this pushes them out of the community. Just to give a bit of an explanation as to how tenants are assessed, there's really two criteria. They look at credit record, and the eviction record almost serves as a second credit record, where if you have that, it drastically limits your options. Aside from second chance housing, there are private landlords who will rent to people under certain circumstances, perhaps a larger deposit and such. However, people who have faced an eviction are ordinarily not the people who can float such an onerous upfront requirement, such as an increased deposit. So this drastically limits housing options. And as far as timelines, evictions ordinarily stay on a record for 6 years right now. So 6 years is a long time if you're a tenant.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair, and thank you both for the presentation. And I think that I'm understanding what you're trying to accomplish here, and honestly, I think it's a noble cause. One of my questions, and I'm going to apologize because I don't know this particular area law, but when these types of motions are filed, we're going to give automatic sealing if the landlord fails to respond to that motion. Can you clarify in this context, what is the notification procedure to ensure that landlord is given proper notice to give them the opportunity to respond and avoid, missing their opportunity to respond?
Jonathan Norman, for the record, thank you. So these cases they're open cases, so it's a motion into a case, so it's not like the filing of a new petition. And so they will get an e-file and serve notice, and then the practice is also to mail a notice to the address that they have on file and to file then a certificate of service.
Okay, thank you. Our next question is from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. I do have a question. I have worked a lot with renters early on in my real estate career, and this was one of the biggest issues for them, not being able to move forward with the application and being denied, and just seeing the look on their face was always devastating to me, especially when it was a family, because it does provide stability for their family and their children. I do have a question as far as this particular bill. Are other states already doing this, or are they considering something similar?
Jonathan Norman, for the record, thank you. I did not do a survey of other states. I can follow up and do that. What I think, one of the reasons I hesitate for that analysis for Nevada is we have a pretty unique summary eviction process, which we're going to be talking about in the next bill, but it is the only jurisdiction in the country where the tenant is filing their answer prior to the complaint being filed. And so I think when you put the tenant give them such a burden that they have to essentially initiate a lawsuit against themselves, I think examining how other states that have an ordinary civil process where a complaint is filed followed by an answer doesn't make as much sense to me, because we do have that unique summary eviction process.
Erica Roth for the record, and I will just add to that. Thank you so much for that question, Assemblymember Moore. I appreciate your recognition of having to interact with people who are seeking that housing. When I was a legal aid attorney, I have a very distinct memory of many of my clients who were seniors living on fixed incomes who were facing evictions and sometimes were evicted. It was very difficult, if not impossible, to find them additional housing, especially if they had no other family members or support. And sometimes these were people in their 80s and 90s. It is devastating and heartbreaking. But the state of Nevada has, recognized the importance of record sealing because of the barriers that it causes with that recognition. But, it's additionally more important in the state because of our summary eviction process. So when you think about my 85-year-old client who was living not even on Social Security but SSI, she was taking in, $735 a month or whatever it was at the time. She was not able to navigate that summary eviction process, and she came to us too late. And so at that point in time, that's why record sealings are so critically important in the state of Nevada because of our summary eviction laws as well.
Thank you so much. And our final question will be from Assemblymember Hanson.
Thank you, Chair. It's good to see you. Thank you for being here. I just wanted to get some clarification when you mentioned the three things that the bill does. I'm just curious that if there's that 1 year, the 1 year after 1 year, I was curious is that waiting, what was the policy reason for that 1 year? And does that presumption apply for any reason for evictions? Like you mentioned nuisance evictions. So if you could maybe address that for us on the nuisance evictions and the policy behind the 1 year.
Jonathan Norman for the record. Thank you for the question, Assemblymember Hanson. So the policy for the 1 year, a tenant could apply for record sealing prior to a year. They just won't have the presumption. And so the year is set as a time that has passed where we can envision the circumstances of an individual changing so much so that they should be able to start with a clean slate, right? And it's really a value judgment about how long that eviction should bar someone from being in the ordinary rental market that you or I or most of the people in this room could take advantage of. And so that's the policy situation behind that. As far as nuisance goes or other forms of eviction, I think I'm going to turn that over to Mr. Haley, but I will say for a nuisance, the person is a nuisance. Like sometimes people think that the landlord could be upset with the tenant and that makes a nuisance, but that's not it. It's the tenant has disturbed the enjoyment of the property of the other tenants. And so just want to make that clear. And then Nick, I don't know if you have anything to add.
Nicholas Haley. Yeah, a couple of items regarding that. First, the categories include a number of other types of evictions, including what are called no-cause evictions, where there's literally no fault of the tenant. It's simply the landlord wanting the property back. Nuisance includes things such as waste, but it also includes unauthorized tenants. And one thing we sometimes do see is where somebody takes in somebody who has no place else to go, or they have a caregiver who spends time with them because they have increased needs, but that caregiver isn't on the lease. These things fall under the heading of nuisance and can have, they're probably the easiest route to somebody losing their property because nuisance evictions are the easiest. They're only a 3-day notice and they're difficult to defend against. So this would apply to those. I can see your point in the question in why would we want to grant that opportunity in a circumstance where it's something a little more egregious? But I do think you do have to look at these cases on an individualized basis because some of these I think would still have merit to be sealed after a year. So, and I think that really applies across the board with the non-payment issues, all of these. I do think these are fair to be before a court where they do this weighing of interests.
Erica Roth for the record. Just a final point on that. I had a case once as a legal aid attorney where my client, who was in her 80s, was continuously served with nuisance evictions because she was too weak to take her trash to the curb. And it would pile up, and she did not have family to assist her in helping her take it to the curb. And so what this bill does is it still allows her in that situation to be reviewed by a judge, but I think it's easy to fall into the trap of nuisance means that someone has done something wrong, and that's just simply not the case all the time. We have a lot of people who are are struggling in so many ways. And what this bill does is it ensures that there is due consideration given to those circumstances. It allows them to initiate a proceeding where a judge, if the landlord determines that they think there was a real nuisance, that can be reviewed by a judge. But it also allows that woman who was too weak to take her trash to the curb is able to find additional housing, reduce those barriers to housing in the future.
Okay. Thank you so much. Just a moment, please. Okay, with that, I'm going to go ahead and open it up for testimony. A few things that I'd like to inform everyone of. One is that we have an overflow room now because of the number of people that came to engage with this bill. The overflow room, for those of you that know the building, is 1214. So that's the old Senate chambers downstairs. Unlike typically when people are able to testify from the overflow room, they are not able to testify from the overflow room today. So that means we need, there will be people, as I see many in the hallway right now, trying to coordinate to get upstairs in enough time in order to testify. I said at the beginning of today's meeting that I will be taking 20 minutes for support, 20 minutes for opposition, and 20 minutes for neutral testimony. Let me be very clear, because I'm looking at a lot of T-shirts, so that and T-shirts in the hallway, so that kind of tells me what you're all here for. With that, remember, it is absolutely okay and it is absolutely considered and valid to say ditto. It is okay to say, I'm here in support. My name is, and I'm here in support. I know there are a few people in every position that may want to use their full 2 minutes, but remember, if you use your full 2 minutes, that's someone else who doesn't have the opportunity to testify. So I ask for everyone, whenever given the option, or whenever it's your turn, you are more than welcome to just say your name, spell it, and say ditto, or I'm here in support. With that, I can also, for people who don't want to speak, but are in support, I can also have you, at the end of the 20 minutes, whoever doesn't have the opportunity, I will count the individuals that are here in support just by hands or standing up, okay? So with that, just want to remind everyone, and also for when we say 20 minutes, that includes 20 minutes here in Carson. It would be Carson, Las Vegas, and on the phones. So with that, I will have you begin, but again, reminding everyone to please state their name, spell it for the record, and then begin. So please begin with support testimony.
Good morning, Chair Miller. Thank you, members of the committee. I appreciate folks kind of bearing with us as we entered and exited the room a few times. I will say, just in response to your note, if I could close positive testimony for 283 to do kind of the conclusive, to keep track. Okay, I'll just try to best guess.
Going.
Thank you. Thank you, Assemblymember Roth, for bringing AB 201. I think she and Mr. Norman laid out very clearly. Also, excuse me, my name is Ben Innes. That is BENINESS. I'm the coalition manager for the Nevada Housing Justice Alliance. We organize and advocate with tenants here in Carson City. Just to highlight what they brought up, we had a eviction court watching program all throughout 2024 in Las Vegas. We saw over 600 hearings. The average hearing length was under 4 minutes long. We saw an extreme imbalance in the use of discretion into questions that were raised. What is the impact? So in the matter of minutes, cataclysmic effects on a tenant's lives that then not only affect that present moment, but then last for years and years and ripple outward. So this is a huge supportive bill in terms of access and equity and limiting discriminatory barriers, and that is why we support it. Thank you.
Good morning, Chair and members of the committee. My name is Riley Svensson, RYLEY SVENDSEN. and I am the policy specialist with the Nevada Coalition to End Domestic and Sexual Violence. NCE-DSV convenes the statewide Economic Justice Work Group, which brings together non-traditional violence prevention partners to advocate for increased economic equity, which the CDC has determined is as one of the most effective ways to prevent and intervene in violence. This unique work group has 5 priority areas in which we focus, one of them being access to stable and affordable housing. Evictions impact an individual's ability to seek and obtain housing, which often forces them into unsafe situations with increased risk for violence. Furthermore, housing accessibility is often reported as the #1 barrier for an individual leaving an abusive relationship. Housing is already difficult enough to obtain in today's landscape, and eviction records only amplify this issue. And while landlords cannot evict someone for experiencing domestic violence, many victim survivors find themselves faced with an eviction due to nuisance orders, or because they simply cannot pay their rent on time due to compounding economic abuse and coerced debt. Given that Nevada is already facing a housing crisis and frivolous eviction filings only amplify this issue, AB 201 provides an opportunity to improve access to safe and affordable housing, especially for Nevadans already forced to the margins. It is violence prevention, and we urge you to support this important measure. Thank you.
Good morning, Chair, members of the committee. Secretary, my name is Zachary Khan, ZacharyKhan. Gotta say, it's pretty cool to be on this side of the desk for once. I think it's a reasonable bill. It doesn't look like there's anything extreme in this bill language. Ultimately, I think it makes things a little more fair between tenants and landlords. I think we as a society should be removing any barriers to address our housing crisis in Nevada. And if we're truly serious about solving that crisis, I think this bill is a good step in that direction. To Jonathan's point earlier, Deutsche Bank and other economic groups are giving us a 50-50 chance of a recession in the next few months to a year. And I think renters are going to bear the brunt of that. So I think with this bill, we shouldn't punish those renters for bad economic policy that is decided in Washington, D.C. Above all else, though, I believe that people deserve second chances. And I think that's the heart of this piece of legislation. Thank you to the team working on this bill, to our friend in the South, and thank you, Chair, for my comment.
Good morning, Madam Chairs. Nice to see you. For your record, I am Maggie Carlton, M-A-G-G-I-E, Carlton, C-A-R-L-T-O-N, here today representing Culinary Workers 226 and the 50,000 members who helped build this state. We have to all admit that the 2020s have been very, very tough on working families. Things happen to them that they would have never been able to be prepared for. This bill is an opportunity for them to get back on their feet and provide for their families the way we all want to take care of our children, our parents, our grandparents. So this will give them that opportunity to plead their case that something extraordinary, something traumatic happened to them, and they'd like an opportunity to move on and do better in the future. So thank you, Madam Chair, and thank you to the sponsor and to Legal Aid for tackling this very important issue.
Right now, I'm just going to take a few moments and go down to Las Vegas and then come back to you all, okay, please. Las Vegas, proceed.
Good morning, Chair and members of the committee. My name is Sue Birch, S-U-E-B-U-R-T-C-H. I am the Executive Director of the Nevada chapter of the National Organization for Women, and we strongly support this bill and thank Assemblymember Roth for bringing this forward. Thank you.
Good morning. My name is Kimberly Ireland. Kimberly spelled K-I-M-B-E-R-L-Y. Ireland, I-R-E-L-A-N-D, and I am a proud culinary union member. I was evicted during the pandemic because I had a landlord who no longer would work with the rental assistance programs that were provided back then, and she did everything she could to aggressively push me out. 5 years later, I continue to struggle. I'm currently living with my parents since I am unable to rent a property because of the eviction staying on my record. When I inquire to try to get the eviction record sealed, I'm told that I would have to pay the old balance, which is thousands of dollars. Who has that? Being evicted should not destroy my future. Therefore, I support AB 201 because it would protect renters like me. Thank you.
Hi, good morning, Chair Miller and committee members. My name is Brian Harris, BrianHarris. And for the sake of the time, I would like to ditto the comments made by everyone else in support of this bill. I do think it is a great bill, and I would like to thank Assemblymember Roth and other folks that are working on this bill. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to testify in support at this time? Okay, we'll move back up here to Carson City. Again, great example, Las Vegas with our dittos. Let's proceed.
Good morning. My name is Jody Hocking, JODIHOCKING. I'm testifying. I'm the founder and director of Return Strong. I represent about 3,000 families who are impacted and incarcerated people who are impacted by incarceration, and the families that then are left, and so many of our base deal with housing insecurity and issues. I'm going to actually share my personal story. Housing insecurity has been something that has really, I don't even know if I can do this without getting emotional, shadowed my life really for many years. Not because I didn't want to pay rent. I was a single parent. My partner was incarcerated, and we were dealing with everything on our own, right? In 2019, when he went to prison, we lost our housing. We lost the lease that we had because of his arrest. Didn't have anything to do with me, but I got left holding the bag and trying to figure it out, take care of kids, grandkids, all of those things. 6 years later, I got an eviction immediately. I got a second eviction 2 months later because I got laid off from my job. I spent the next year living in my car. When most of you were learning about Return Strong and we were starting to show up in 2021, I was living in a Jeep at the time and started this organization. Following that, it's now 6 years later. I was like struck when they were saying 6 years. 6 years later, and I just got my first apartment. I have lived in weeklies. I have lived in my car. I have lived in all of the times when I've been here testifying and running an organization. People just never knew because I could never get out from under those 2 evictions. Even though I've paid the civil, I know Assemblymember Gray asked about it. There was a civil. We had the eviction and a civil and the separate, and I paid those bills.
Ms. Hawking, I'm sorry, but your 2 minutes are up, and we have so many other people.
Yeah, I'm sorry.
Thank you so much.
We appreciate this bill, and it's really powerful.
Thank you.
Good morning, Chair and committee members. My name is Phyllis Carpenter, PhyllisCarpenter. I am a leader with Plan and a housing activist as well as an advocate. I am in support of AB 283. I live in Las Vegas and I live in low-income senior housing. In November, I received the first 30-day notice to perform lease conditions or quit. This was retaliation and intimidation by staff and management because I want accountability for the repairs that still have not been done since January of 2020. When I moved, their grievance procedure was not the same as the one that they took upon me at the last 30 day. They don't follow their policies or procedures. I was forced to sign a last chance agreement when I never even got a first chance. I was served another 30-day, if I didn't sign the last chance agreement, they was going to give me a 5-day unlawful detainer. So I signed it, and now I received another 30-day to vacate or quit because they made lies up against me. Right now, I'm facing homelessness, and I shouldn't be because they didn't do the repairs. And that's why I'm in support of this bill, AB 283. Thank you.
Thank you. And we are on Assembly Bill 201 right now. So we'll just move that testimony for support for 283. No problem, not at all. Proceed, please.
Good morning, Chair and committee members. Sarah Evans, SARAEVANS. I'm with SEIU, and we're in support of the bill, and ditto for all the other reasons. Thank you.
Thank you so much. Right now, we're going to move to the phones because we do have some callers. AVN, will you please open the lines?
If you would like to testify in support of Assembly Bill 201, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 201, please press star 9 now.
Hello, members of the committee. My name is Paula Luna, Paula-Luna, and I'm the Deputy Director for Battleborn Progress. I would like to ditto what has already been said. We are in support of this bill and thank Assemblymember Roth for bringing it.
Thank you. Next caller.
Good morning, dear members of the committee. My name is Yesenia Moya, Yesenia. I'm calling today in strong support of AB 201 because this bill is about the ability to rebuild our life after hardship. I am a survivor of domestic violence, and I left my abuser in the middle of the night with nothing but the clothes on my back. My name was the only one on the lease, and I had no idea he had stopped paying rent. By the time they served the eviction, there was no way that I could know, nor that I could respond because I was in survival mode trying to stay safe. And that eviction has followed me, making it nearly impossible to find stable housing. For over a year, I was homeless, couch surfing wherever I could. I was denied at over 40 different properties, spent more than $2,000 in application fees, money that I did not have. I'm still facing barriers. I've applied to over 30 more rentals only to be forced into leasing agreements with landlords who know they can take advantage of people like me. Right now, I'm fighting another landlord who refuses to respect my emotional support animal and is actively threatening me and demanding an illegal fee. This is the reality for many of us trapped in a cycle of housing insecurity due to an eviction record that should have never followed us. This bill could change lives, and it will allow survivors like myself to move forward to access stable housing without being punished for circumstances beyond our control. We deserve a second chance, and I urge you to pass this bill and give people like me a fair shot. Thank you.
Thank you. Next caller.
Hello, my name is Andy O'Connor, ANDYOCONNOR, and I have also been threatened with eviction due to a domestic dispute that luckily it was resolved before it was filed, but for that reason, I would like to ditto all previous comments in support of this bill. Thank you.
Thank you. Next caller.
Good morning, Chair and members of committee. My name is Luisa Benasano. For the record, LuizaBenisano, and I am the Campaigns and Community Engagement Manager for Planned Parenthood Votes Nevada, and I'd also like to ditto in support of AB 201. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in support at this time.
Okay, thank you so much. We have just under 5 minutes for support testimony. If there is anyone else that would like to testify in support, either here in Carson City or Las Vegas.
Good morning. My name is Michelle Van Collins, MICHE. Oh, I'm sorry. Did I? Oops.
Keep going.
VAN. Oops. I am in support of this bill as a person that has been homeless for the past 7 months, unfortunately, due to an eviction, and that prevents me from being able to find a place to live. Unfortunately, we don't have enough time to discuss, more of the specifics, but being in support of this bill and making this bill come to fruition can give people like myself who are unhoused an opportunity to move on and find a more stable way of life and a stable way of living. Thank you.
Next person, and we're at about 3 minutes.
Ok. ¿Qué tal? Buenas tardes, buenos días. Soy Juan Martínez. Soy miembro de Make the Road, Nevada, y solamente quería exponer que estoy de acuerdo con la ley AB 201 y AB 2A3. Y estoy de acuerdo porque son buenas estas leyes. Gracias. Eso es todo.
Thank you so much. And I heard support testimony for both of our bills today, and that will be recorded. Please right here in Carson City.
Yes. My name is Michael Tang. I'm a volunteer with Faith in Action Nevada and also a volunteer with St. Vincent de Paul Society of Nevada. We helped over 285 people last year with rent, electric bills, and gas bills, heating bills. And so ditto, and if you keep them in mind that people are struggling, so there's a lot of people out there, and that's just 3 motels in Reno, so thank you.
My name is Asaki Hardy, AHSAKI, last name Hardy, HARDY. I represent SEIU, and we support this bill.
My name is Rihanna Meadows, pronouns she, her. I'm a housing justice organizer with Make the Road Nevada. I'm in support of AB 201 eviction records. I'm there doing a lot of the court monitoring. They're quick to give out the eviction, but not quick to still sealing it. So yes, I'm in support of AB 201. Thank you so much.
Thank you so much. We have time for one more testimony. All right, not seeing anyone, we did it with 1 minute and 30 seconds to spare. But with that, if there is anyone here in Carson City or Las Vegas who did not verbally testify but would like to be counted in support, please stand up. If you did not speak. I have 22 in Carson, I believe. How many people are standing in Las Vegas? We're in Carson right now. How many are standing? Remember that long trip? How many are standing up in Las Vegas right now? Is anyone standing? Okay, so I think we'll just go with please add 22 people in support of Assembly Bill 201 to the record. Thank you so much. With that, we will begin 20 minutes of opposition testimony we'll first start here in Carson City and then bounce down to Las Vegas and the phones as necessary. So anyone wishing to approach to testify in opposition? Not seeing anyone, we will go to Las Vegas. Please begin. Whoops.
Good afternoon, Chair Miller and Assembly Judiciary Committee members. My name is Azim Jessa, AZIMJESSA, and I'm the Legislative Chair for the Nevada Realtors, and I'm here in opposition to AB 201. First of all, let me say that we are continuing to work with the bill sponsor, so thank you, Assemblymember Roth, and we're working towards an agreeable solution. My initial concern was actually the question was asked twice by Assemblymember Urick and Hardy, so thank you, both of you, for reaching out about that. Another area of concern we do have, though, is the changes on page 3 remove that judicial discretion, which was purposely included in the law, by stating that a presumption to seal the record after 1 year is in the interest of justice and should not be outweighed by the public's interest. That discretion is important to us to allow a judge to consider the circumstances that resulted in the eviction. If a tenant has fallen on hard times and is unable to pay, we believe that should be viewed very differently by a court than a tenant who was evicted for illegal activity. Lease violations such as operating a meth lab, animal hoarding, or subletting without the owner's consent are public safety issues and outweigh a tenant's desire to seal these actions. Currently, our esteemed judiciary can weigh all the factors and determine if the interests of justice require sealing, including the length of time since the eviction was ordered and the basis for it. The proposal effectively removes judicial discretion and removes the judge's ability to consider the public's interest if the motion is filed more than a year from the order of the eviction. The Nevada Realtors favor judicial discretion over such a bright line presumption. Thank you for this opportunity to speak this morning, and we look forward again, like I said, to working with Assemblymember Roth.
Good morning to the chair and committee. My name is Alex Falcone, ALEX-FALCONI, and I'm testifying in opposition to AB 201 on behalf of the Nevada Open Government Coalition, the Nevada Press Association, and our Nevada Judges Incorporated. As we have repeatedly stated, statutes that automatically seal cases implicate First Amendment concerns because they interfere with the ability of the press and the right of the public to observe and supervise the operation of the court. This is especially crucial when it comes to our state because of the unique procedure this legislature has set forth for summary evictions. To the extent it is the legislature's intention to enable evicted tenants to more easily obtain housing, we would suggest narrowing the scope of sealing and redaction to the identities of the tenants only. Though I cannot concede this would survive constitutional scrutiny, it would at the very least limit the interference of any news gathering to the bill's intended purpose. This bill could easily have the unintended consequence of concealing patterns of exploitation, misconduct, or incompetence. This is something that recently occurred when a KRNV news reporter was denied access to a JABS video the Commission on Judicial Discipline relied upon in its public reprimand of one of our judges because of an automatic sealing statute purporting to protect families. I want to stress that it is not our position that we are categorically opposed to sealing, only that it must occur with the exercise of judicial discretion on a case-by-case basis where the judge presiding over the case evaluates the particular circumstances of that case. This is consistent with the First Amendment principles articulated by our Supreme Court, which has held that, quote, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing, unquote. No further comment.
Thank you so much. Is there anyone else there in Las Vegas that would like to testify in opposition? Not seeing anyone. AVN, will you open the phones?
If you would like to testify in opposition to Assembly Bill 201, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 201, please press star 9 now.
Hi, my name is Ron Ariel, A-R-Y-E-L, for the record. I'm testifying in opposition to this bill because when you seal records and landlords don't know the history of the tenant, what's going to happen is the same tenants are going to be evicted over and over and over again from housing. And what that does is it increases the costs and the amount of work that leasing agents and rental agents have to do. Increase the cost of the landlord, and that's going to lead to rental increases in rent to cover those costs. I understand the emotional appeal, but I heard some false statements made by the proponents regarding some of the percentages, and I've heard a lot of exaggeration. And I'm not saying that there are not tenants who are suffering, because there are, but I'm hearing more of a kind of a very, very popular emotional appeal for this bill rather than, some hard numbers and actual benefit for tenants. So this is a bad bill, and I'm urging that it not be passed, and I'm going to recommend to the governor that he veto it. But if the bill is amended, certainly I would be open to any amendments that might be said. But right now, the bill is a bad bill, and on objective grounds, and I'm absolutely opposed to it.
Thank you. Next caller.
There are no other callers choosing to testify in opposition at the.
Thank you so much. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City.
Good morning, Chair Miller, members. Mackenzie Warren Kay, Warren Kay, on behalf of Ovation Development and the Nevada Multifamily Alliance. We are here neutral on this bill. Want to acknowledge the sponsor, also Mr. Norman, for taking several meetings with us. Specifically, I can say that we are in favor of Section 1, Sub 2E on the appeal. We believe that if a tenant is successful on appeal, that should absolutely be sealed. There are some forthcoming amendments, as you heard. We want to review those amendments. Certainly appreciate the back and forth on those evictions that fall outside of non-payment of rent. Those are real issues. We believe in what the sponsor is saying, that these apartment communities need to be safe, stable, resilient. Landlords want long-term tenants. That is the goal. An eviction is an unfortunate tool that exists in our tool belt for a reason. An eviction is just one data point that we review. Also wanted to just put some parameters on the statement that an eviction would act as a forever bar. That's simply not true, at least for our members. It's one thing that we analyze. We look at the time period. Did it happen around, the pandemic? Does the tenant have an explanation for what occurred? So these are important factors to weigh, but I think the intent of the bill is to provide housing and to ensure that when people are filling out an application for an apartment, it's not an automatic disqualification because of an eviction. We can get behind that. It's just fine-tuning some of the language. So again, we look forward to working with the sponsor and Mr. Norman. Certainly appreciate you, Chair, for hearing the bill and for some of the member questions that teased out our concerns. Look forward to continuing to work. Thanks.
Thank you. Is there anyone else here in Carson City for neutral? Not seeing anyone in Las Vegas. AVN, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 201, please press star 9 now to take your place in the queue. Again, if you would like to testify neutral, please press star 9 now. Chair, there are no callers choosing to testify in neutral at this time.
Thank you so much. Then I will go ahead and close the testimony and close the bill hearing on Assembly Bill 201. You do not want to be the reason we have to recess. So with that, I will go ahead and open the hearing for Assembly Bill 283. Assembly Bill 283 revises provisions governing certain actions and proceedings relating to real property. Is our bill presenter here? He will be the reason we recess and come back tonight. Oh. Assembly member, I am going to have you open, and when your co-presenter gets here, he may join. We have to be on the floor at 11:30. Proceed.
Yes, ma'am. I apologize. I figured that we'd still be going long on testimony. This is Max Carter, Assembly District 12, and today I'm here to present Assembly Bill 283. And what we're talking about with this bill is the summary eviction process that was alluded to in the previous bill, and about how that we are the lone outlier that puts the onerous on tenants in our entire country to take and file with the court. And with that being said, and I can tell you, it's a huge problem. And I'm going to turn it over to my partner, Jonathan Norman with Legal Aid of Southern Nevada. We also have, same man, Mr. Nicholas Haley down south. Thank you.
Chair, members of the committee, Jonathan Norman with the Nevada Coalition of Legal Service Providers, NORMAN. We're joined by Nick Haley, a legal aid attorney who does evictions every day in Southern Nevada. For the presentation today, I have a very short slide deck that just goes through what summary eviction is, just to make sure everybody's familiar. And then Nick will do a walkthrough of the bill, and then we'll be ready for questions. We did provide 2 overviews, which should be on Nellis, of the summary eviction process. So one is what the current process is, and the other is what would the process be if AB 283 was passed into law. So if anyone needs to reference those to see the change, you can reference it there. So now I'll walk through the PowerPoint. So summary evictions in Nevada. Currently, the law is, this is the only civil process that we're aware of in the country where the tenant has to file the first pleading in a court of law. And so why that matters is often people will say every jurisdiction has a summary process, and that's accurate. Summary just means fast, right? So a quick process, and every jurisdiction that I'm aware of does have a fast process. What makes Nevada unique is it is incumbent upon the tenant to initiate the lawsuit against themselves, and that is what at the core this bill seeks to change. So step one, the landlord serves an eviction notice on a tenant. Now, there are several types of eviction notices. They're all encompassed in this bill. To make it easy, I want to talk about by far the most common, which is a 7-day notice to pay or quit. So that's when you are behind on your rent. Within the notice period, the tenant has to comply with the notice by vacating the property. That's one of their options. Paying rent. And then I have the other for curing a lease violation, but that wouldn't be for the non-payment of rent. Often no eviction is needed. So there's numerous circumstances where somebody gets a notice and they cure or they vacate, right? And then there is no court filing, and we have no record of that case existing. And to put into some perspective, in Nevada, last year there were about 85,000 summary eviction cases filed in the state. That does not account for the number of cases where somebody receives a notice, but the case does not proceed. Step two, after the notice period, the landlord files a complaint to request eviction, and the landlord serves the complaint on the tenant. So currently, under Nevada law, the tenant has to file an answer within that 7-day period, right? And if they do not file an answer, and after the 7-day period, the landlord files the complaint, the eviction is granted, and the tenant's opportunity to respond is gone. They do not have an opportunity to respond once the complaint is filed. This bill would switch that, where the complaint comes first, is served on the tenant, and then the tenant has a period of time to respond. So that here is the tenant would have 7 days to file the answer in the justice court where the property is located. If the tenant does not file an answer, then the courts would grant a summary eviction by default because there has not been a response. If the tenant has filed an answer within the notice period, then the court would set a hearing. And then at the hearing, if the judge grants the eviction, then the notice goes to the constable's office and the tenant is locked out. And then there is an opportunity for a tenant to file a motion to set aside to get an extra 10 days to move out. And then the final process, if at a hearing the tenant has a legal defense, the court does not grant the eviction and requires further proceedings to different provisions of the NRS. And in those instances, we would see cases go to formal eviction, which is a different process not referenced in this bill, not modified by this bill. And so when you think about what this bill does, there's a lot of blue. I think there's like 8 pages of blue. Most of that is the law moving. So when something is going to be in a different section, it's going to be blue, but that doesn't mean it changes the law. So most of the sections are exactly what's in the law today. The big shifts are the landlord files a complaint and the tenant has a period to respond. That is the one sentence shift in this bill that took 8 pages of blue plus a number of other blue words throughout. So just think of that. One thing is changing. We are having the landlord file a complaint and the tenant has an opportunity to respond after that complaint is filed. This follows every civil process in the United States of America, follows every civil process in landlord-tenant law around the country. This is the only process where a tenant has to initiate the lawsuit against themselves. And just think of how absurd that sounds. We have a situation where somebody has to sue themselves or they lose their right to respond. And then think about how you would apply that to any other area of law and just play out that absurdity. With that, I'll turn it over to Nick to do a quick walkthrough, because like I said, 8 pages of blue, one sentence is changing really, and the rest just supports that.
Thank you, Jonathan. Nicholas Haley, Legal Aid Center of Southern Nevada. I'm a staff attorney focused on evictions and housing issues. Jonathan's summation pretty much encapsulates the changes overwhelmingly, those 8 to 10 pages of blue are just changing the order of answering complaint. As Jonathan noted, this is the only jurisdiction, and it's the only practice area. As far as we know, this is the only procedure before a court where the answer precedes the complaint. And the primary change that is caused by this law would be to switch the order to be consistent with literally everything else. Section 2 does also set some timelines. It states, for example, timelines for filing the complaint, service of the complaint. The contents of the complaint mentioned in the highlighted areas is generally consistent with current process. There's just a few minor changes because of the timeline and things of that nature, but as far as the content of the complaint and answer, those are largely unchanged. The complaint has to be served with a summons advising of the right to file an answer with the court, so there's some additional language that would be on the complaint just because the order switches. Subsection 11 under Section 2 requires proof of service to be filed before a summary order is issued. So there is a change as far as requiring a proof of service before the execution of the eviction order. Otherwise, it's largely consistent with current law. Going down to Section 3, that's generally consistent with the current law under NRS 4253 sub 5. It's a little less explicit as to the timeline. As the law is currently written, it says that the landlord will post the eviction order and return no sooner than 24 hours and no later than 36 hours. This gives the tenant a timeline for when the eviction is actually executed, when the lockout would occur. So for those of you unfamiliar, an eviction order is necessary for the landlord to authorize the constable for the area to come out and perform the lockout. And what happens is the eviction order is ordinarily posted on the premises by the constable, and the order states that the constable will return within 24 to 36 hours to perform the lockout. So the constable basically comes twice, one to give a warning that I'm coming back in 24 to 36 hours, and then they come back the next day to actually change out the locks and remove people from the premises. There is some ambiguity, as I see in the amended version, as to the upper limit of when they return.
And Jonathan Norman, for the record, it is the bill, not an amendment. When Mr. Haley says amendment, he is speaking about the bill amending the law.
Thank you. I appreciate that clarification again.
Yeah, my apology for my imprecise language. Going down to sections 4 and 5, those address what is currently NRS 4253 subs 7 and 8. Those are consistent. Section 6, there is a little bit of a change to the status quo. That amends NRS 4254. Essentially, we have two sections of the law that deal with summary eviction. Jonathan said summary is quick. That is the case. Summary eviction is also, generally speaking, a proceeding where there's no fact finding. This is where the case is ostensibly uncontrovertible. It's accepted facts, and by operation of law, the landlord is seeking relief. So there's two processes. One is just for non-payment of rent. There's a separate process that's almost exactly the same for all other theories of summary eviction. This includes no cause, lease violation cases, nuisance cases, tenancy at will, any other theory except for non-payment of rent. So there's two processes. The main difference between the two processes is this. When there's a non-payment case, there's one notice. When there's any other theory for summary eviction, it's two notices. It's an initial notice followed by what's called an unlawful detainer. And that's in part why the highlighted text in blue is so long, because we're going through the process, which is almost identical twice. And that just added some bulk to it. It does appear that changes are consistent as far as the timelines. There are some new timelines created under the bill, just to account for the fact that the order changes. Elsewhere, though, this is This is largely the only real substantive change is the order of complaint and answer. I did see under section 9, we're removing language we added a few sessions ago regarding COVID. I think that's just housekeeping largely. The COVID emergency was declared ended, so we're not dealing with that. And I think that's just being removed from the statute for housekeeping. Other than that, that is the gist of this bill, which is just to change the order of answer and complaint. And I'll leave it at that.
And Chair, if you look at and members of the committee, so Section 2 and Section 6 are where the change is happening. The rest is moving things from sections in the current NRS to new sections. So the substantive changes are Sections 2 and 6. Jonathan Norman, for the record.
Chair, this is Max Carter, Assembly District 12 for the record. And in summation on this, we're trying to create balance. We're trying to come into the accepted norm in our country. You know, and there's been this argument that, well, landlords are Nevadans too. Of course they are. And we're here to represent all Nevadans. Increasingly, we're seeing corporate and out-of-state landlords come in and prey upon Nevadans. And we need to bring it back to where there's equity and balance in it. And then, why do we bring back a bill in a little bit tighter form than one that was vetoed last session? It's because we believe in second chances. Let's give the executive branch the second chance to do what's right for Nevadans, all Nevadans, not just corporate landlords. Thank you.
Thank you so much. And with that, I will go ahead and open it up for questions. Our first question is from Assembly Member Gonzalez.
Thank you so much, Chair, and thank you so much for the presentation. I just had a clarifying question. I think you went over it in your presentation, but just for the record, can you again state how many Nevadans that this impacts?
Jonathan Norman, for the record. Thank you for the question. So the Nevada Supreme Court publishes an annual report, and in the appendix is the number of summary evictions filed in a year. And I believe in 2024 we had around 84,000, and in the year before about 86,000. And I want to stress that that does not account for the number of notices, right? Because if a tenant never files a response, if they self-evict by getting the 7-day notice and they leave, or if they were late on rent and reach an accommodation with their landlord, which happens frequently, those are never recorded in that number. So those numbers only reflect cases where a tenant filed an answer or a landlord had to file a complaint. And again, the complaint comes after the answer, and there is no opportunity to answer the complaint once it's filed.
Thank you so much. Our next question is from Assembly Member Hardy.
Thank you, Chair. So my question is, you mentioned with this bill there would be some timeline changes. So if you could just, so everyone's aware of what that is currently, like they serve the notice, how many days for the answer, the complaint, et cetera, and then how those days specifically would change with the bill. And then if you happen to know if there is a hearing set, like how many days is that taking to get before a judge? Thank you.
Jonathan Norman, for the record. So we have our current, and it's on Nellis, but this is our current summary eviction process up on the screen. And the key change is, do you see where it's kind of orange in the upper right-hand corner? The process will now be the complaint is filed, and then the tenant has 7 days to respond. And it is judicial days. And then the second part of your question, can you repeat the second part?
Yeah, I'm just trying to, so it's clear in our minds, like currently, and it can be, generally like, what's the total of days? Is it 45 days we're talking about with the current process, and then the new process, is it still that same amount of days or is it different?
Yes.
And then addition, how long it would take to get a hearing?
So currently, thank you for the question, Jonathan Norman, for the record. So I got it now. The current timeline to a hearing in Las Vegas Justice Court, which if we think about Nevada and those 86,000 evictions, around 75% of them are filed in Las Vegas Justice Court. So they're doing the vast majority. And right now, hearings are running about 2 weeks. That can fluctuate quite a bit. So I know coming out of the COVID, the pandemic, there was a backlog of evictions, and those were getting set at 70 days. Right now, we're down to about 2 weeks. The key change that this makes is it adds 7 judicial days for the tenant to file a response. And judicial days are going to, for lack of a better way to phrase it, it's going to hit different depending on what jurisdiction you're in, because some courts are not open on Friday, right? So Friday is not a judicial day. Some courts are open 5 days a week, and you're going to count your judicial days, 1, 2, 3, 4, 5 that week. You're going to skip the weekend, then you're going to go 6, 7, and on the 8th day, which would be Wednesday, the landlord can, the court would default under the new process. Under the old process, the landlord would then file their complaint. So it is expanding that chunk of time. And, like with any bills, timelines, whether you're on judicial or calendar days, are things we can discuss with stakeholders and move. And I think people would notice in the bill from last session how it ended up is we had negotiated those timelines, and unfortunately that didn't move all of industry to neutral, even though we made those accommodations, because if you switch to calendar days, right, you're going to count the weekends, you're going to count that Friday that the court's closed. So this bill still sets it out as judicial days, and happy to hear from stakeholders about how that impacts landlords.
Thank you, because that was kind of another little question I had was you mentioning the judicial days. So thank you for adding that.
Thank you so much. The next question is from Assemblymember Cole.
Thank you, Chair. So I was going to ask the same question basically that my colleague just did, but you've mentioned that a vast majority of this bill is just moving existing law into this section because LCB said that it needed to be. Can you give us the references, and you don't have to do it right now, but perhaps in an email to the entire committee, what references these sections all go to so I can see what section of NRS we're talking about? Thank you.
We'll have legal respond to that.
Hi, Carly O'Krent for the record. Assemblywoman Cole, you'll see the sections referenced in the digest at the end of the first paragraph. So it's NRS 42553, 42554, and 42542. Those sections are also being repealed in the final section of the bill. I think it's obviously, up to the committee to determine, and the bill sponsor to determine how to proceed with drafting a bill like this. The reason for the repealing of those sections and reenacting them in blue language is that it's very difficult to read a bill when you've saved the word "the" and the word "a" in every few things. And because of the manner in which they're changing who files first, you'd have a whole lot of red interrupted with blue occasionally, and then that becomes even more complicated as the bill is amended on the other side. So there is no reason that the bill couldn't be drafted in a different manner. That's a policy choice for the sponsor of the bill, but that's an explanation as to which provisions are being repealed and reenacted and why it's being done the way it is.
Thank you so much for that. Our next question is from Assemblymember Urick.
Thank you, Chair. And I want to just say, really, Assemblyman Carter, how much I appreciate the comment that you made about bringing a bill back and looking for second chances. And I love this legislative process. And just because I didn't get through the finish line the first time, we're back here, we're debating. So I thoroughly appreciate that. And I want to be on record here and say I thoroughly appreciate the attempt of this bill and what we're trying to do. When we're making these types of policy decisions, of course, we're always trying to balance, right? Find a balance. And one of the things that I always find myself doing is trying
Assemblymember,
to...
is there a question, please?
Yes, Chair. I'm trying to make sure or assess the unintended consequences. And so when we talk about all Nevadans, you mentioned corporate, right, landlords that certainly could absorb some of these costs that are going to be and delays that are going to incur with this process or this policy choice. My concern is for smaller landlords. And my question is for those folks that are really paying their bills on a monthly basis, an extra week or 2 or 3 could actually maybe drive some of these folks that are providing these housing opportunities out of the rental market. And so my concern is that, and so my question is, do you have any concerns, or is there anything that this bill can do to mitigate that risk of forcing maybe some of our smaller landlords that are providing these housing opportunities out, and therefore limiting our supply and driving up costs?
Thank you very much for the question, Assemblyman Yerk. Max Carter for the record. Excuse me. What I would say on that is the other 49 states, this isn't an onerous burden on small landlords. And unfortunately, we're tipping more and more to corporate landlords. My district is upwards of 40% corporate landlords. And we need to take and create that balance. And if you've ever attended eviction court, and Las Vegas Justice Court in particular, it is so tilted against tenants that it's ridiculous. It's shameful to watch, and we need to do something to take and restore the balance. You know, they allow landlords to zoom in from out of state. Tenants must show up, must miss a day of work and show up. We need to do something to bring balance back into that. Those eviction hearings last, it's sometimes not even minutes. And we need to take in, give our Nevadans that are in the position of having to rent a little bit more breathing room and create that balance. And so that's my answer.
Thank you so much.
Nicholas Haley, I'm sorry, Chair, if I may.
Please.
May I proceed? The current process right now, we've done the math on this, and I certainly see it regularly. Take the non-payment process, for example. It's one notice. Under the current process that we use, an eviction can go from start to finish, from the first notice to an eviction order, in just under a month. This is a very contracted process. It's very, very succinct, and it's very quick. This change would effectively add, if you do the math on it, it works out to the 7 judicial days of the notice. That effectively becomes the additional time. And then there's a bit of the service, but if the landlord controls the 2 longest timelines, which is filing the complaint and serving it. So this process would not create a very onerous timeline as far as the landlord's concerned. This would be consistent with what we see in most states, and in fact, much, much briefer than quite a few of them.
Thank you for that. Our next question is from Assemblywoman Roth.
Thank you, Chair, and thank you so much for this presentation. My question is actually in regard to the notices as currently served on tenants under the existing law, and why this change is kind of important. In my prior practice, I would often see where service was acceptable, where no one was home, by being left at the premises, and I often saw that that would cause problems, especially for my senior clients. Can you kind of touch on the issues that that causes now, with the burden being on the tenants to actually file and answer, where notice does not always have to be, it doesn't have to be handed to them in all circumstances?
This is Jonathan Norman for the record. Thank you for the question. I'll touch a little bit on it and then turn it over to Nick for, because he's dealing with service every day. But I think, you know, when somebody moves into Nevada or has never dealt with an eviction, the idea that they would have to initiate the lawsuit is a wild concept. And just an example, I practiced in New Mexico before I came here, and I was in a training, you know, going through summary evictions, and they, you know, our directing attorney is saying this is the process, and I was like, no, it's not. I was like, I got out my phone and I looked up the NRS, because I was like, we cannot have a process where a tenant has to file first. So it's confusing for anyone caught in that situation. And then I'll turn it over to Nick as to how notice is most commonly effectuated.
Nicholas Haley, notice typically is effectuated right now through a mailing and a posting. You get for example, on a non-payment notice, you would post this in a conspicuous place on the premises, as well as mail it to the person. This starts the clock of 7 judicial days to respond. And in some cases, what we see is if a person is out of town at the wrong time, they could miss that entire period. They can miss the 7 days. Somebody goes home to see family in Mexico, or they're in the hospital because they had a prolonged sickness, their 7 days goes quickly. This process would put the complaint as the next step in this process, which would give a little extra time for that person to be aware of it. So I think as far as just a due process issue, this would help a lot of people who might miss the notice because the time period right now is just insanely short. I forget the second part of that, but as far as the initial timeline, that 7 days goes very quickly. You serve a notice on a Monday, your answer is due by the following Thursday, so not much time.
Thank you so much. And with that, that ends our questions for the presenters. We will move on to testimony. Again, I believe everyone understands the process for today. We will do 20 minutes for support, opposition, and then neutral. Please, when possible, again, just state your name and say ditto or I agree. With that, we will begin. Please fill the chairs quickly. With that, we will begin here in Carson City.
Thank you, Chair Miller. May I ask a quick question about your...
Please proceed with your testimony.
Okay, I just want to make sure the overflow folks are counted. I don't know if we can see them. Again, my name is Ben Innes, B-E-N-I-N-E-S-S, Coalition Manager for the Nevada Housing Justice Alliance. Thank you, Chair Miller and members of the committee for hearing this bill today. Thank you for Assemblymember Carter and Mr. Norman for bringing it here. This remains a core priority and has been for many years for the coalition and the tenants we organize with and advocate with and for. Housing justice and long-term tenant protections we fight for housing stability, access, equity, and so on, that are immediate and effective now, that, don't need to be wait to build for 5, 10, 15 years, are deeply important. And, we're trying to create that foundation. In regards to summary evictions, we're really coming from out from the bottom. It's a negative that we're trying to catch up from, which has been outlined today, to fix, again, this backwards process that we've talked about. With our cost of living crisis and lack of tenant protections, we have this eviction to unhoused pipeline, and this is an important step in remedying that. And I would, I'll leave it at that. Thank you, Chair.
Hello to the committee and committee chair. My name is Lucetta Keys, L-O-U-S-E-T-T-A, K-E-Y-E-S. I'm from Las Vegas, Nevada, Senate District 8, Assembly District 5. I came home after visiting LA and I had a 7-day notice on my door for failure to pay rent. It was nighttime and I was incredibly stressed out. I could not imagine what this was about. I stayed up all night. I could not sleep. I went to my rental office in the morning to find out what happened, and they told me that I was short in paying my rent $32 over the course of 3 months in a row. It was because of these junk fees. It is a formula. My rent was dependent on a formula that I did not have access to. I did not understand, and it varied month to month. They put a 7-day notice on my door for $32. All they had to do was hit print. That's not fair. They should have called me. If they had to file with the court, they would have called me and asked me why my rent was short every month. Every month after that, I called my office to get the exact amount I owed them. Now, opponents to this bill will say that realtors, landlords need to be protected, and of course they do, but renters need to be protected too. My mother said common sense is not very common, and this is an example of it. They should have called me. I paid my rent every month. I walked in with a check every month. I am fortunate now that I live in an apartment complex where my rent is the same every single month. Thank you very much for your time. I support AB 283.
Good morning, Chair and members of the committee. For the record, my name is Tara Webster, T-A-R-A-W-E-B-S-T-E-R. I'm the policy manager with the Progressive Leadership Alliance of Nevada. I'm here today in support of AB 283. People rent for a variety of reasons. Some are saving to buy, some need flexibility, and some are experiencing financial instability. Regardless of the reasons, all renters are facing historic rent increases. There are greedy out-of-state corporate landlords and landlords who are operating uninhabitable properties with little accountability. This puts all renters at equal risk of eviction and facing an uphill battle to navigate the summary eviction process. This bill is a crucial step forward in tenant protections in our state, promoting long-term stability and safeguarding tenants from unfair eviction. These protections are especially vital for those at higher risk of housing instability, including seniors, low-income households, and communities of color. The Progressive Leadership Alliance of Nevada views AB 283 as a common-sense bill that will make Nevada's eviction process more equitable and more in line with how a majority of other states are operating. With that, we urge your support for this bill.
For the record, my name is Mark Ellis. I'm the president of CWA Local 9413. Ditto.
Thank you. I'm going to move down to Las Vegas. Please proceed.
Hi, my name is Kristen Aviles, Kristinaviles. I am representing HopeLink of Southern Nevada. HopeLink provides rental assistance to tenants facing immediate risk of eviction. We strongly support AB 283 as it grants us additional time to collaborate with landlords and tenants to assess rental assistance needs effectively. This extended time frame allows the qualifying tenants' landlords to receive the back rent that is owed to them while preventing further homelessness in our community. When evictions are expedited, both landlords and tenants may lose access to critical financial assistance that could benefit both parties.
Good morning again, Chair and members of the committee. My name is Sue Birch, SUEBURTCH. I am the Executive Director of the Nevada chapter of the National Organization for Women. We strongly support AB 283 for all the reasons given by the presenters and those that have testified so far, and we thank Assemblymember Carter for bringing this forward. Thank you.
Hi, good morning, Chair Miller and committee members. My name is Brian Harris. I'm here in support of AB 283, and I'd like to ditto the comments made before me. Thank you.
Thank you. Back to Carson City.
Hello, Chair and members of the committee. My name is Isaias Gallegos, ISAIASGALLEGOS. I'm a resident of Las Vegas, Nevada, Senate District 6, Assembly District 34, and I am here on behalf of the Nevada Housing Justice Alliance to testify in support of AB 283. If passed, this bill would make the eviction process more fair and transparent for tenants. As a concerned Nevadan, I have seen the number of homeless citizens rise over the years. These people have ranged from young to elderly and to single individuals, entire families that have been put on the street. While this bill won't solve homelessness at the source, it will start the process of making eviction less biased and more equitable for Nevada's tenants. Thank you for your time, and I urge you to support this bill. Thank you.
Good morning, Chair and members of the committee. For the record, my name is Susie Martinez. I am the Executive Secretary Treasurer of the Nevada State AFL-CIO, and we are in full support of the bill. Thank you.
Good morning again, Chair and members of the committee. My name is Riley Svensson, RYLEYSVENDSEN, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. We are here today in support of AB 283 as housing justice and access are critical aspects of violence prevention. Victim survivors of domestic violence often face co-occurring economic abuse, which leaves them unable to pay their rent, placing them at risk for eviction. The current summary eviction process is extremely traumatizing. When a victim survivor is forced to initiate the eviction process by filing first, they're forced to put their own safety and healing on pause, putting their too often limited time and resources into understanding complicated eviction processes and are forced to find new housing. The summary eviction process puts an undue burden on the tenants, often leading to eviction and forcing them to find new housing in an impossibly short period of time. So not only does this put victim survivors who have already experienced domestic or sexual violence at extreme risk of becoming homeless, when any person experiences houselessness, their risk for experiencing domestic and sexual violence increases. AB 283 is an important aspect of violence prevention, and we urge you to support this bill. Thank you.
Good morning. My name is Taisakan Hall, Taisacanhall. I'm a housing justice advocate and a renter in Las Vegas. I'm here to testify in support of AB 283 because this bill is not just about improving legal procedures, it's about protecting the rights, dignity, and stability of our most vulnerable residents. The current system forces tenants to navigate a confusing, unfair, and disorienting system during a time that is undoubtedly already stressful. In 2018, I experienced the devastating effects of this system firsthand when I was evicted with my mother and my 2-year-old brother at 8 in the morning. We were told there was an eviction notice on the door, even though we were certain there was not. We were given just 30 minutes to gather our belongings, and without a car, it was impossible to carry everything we needed. The emotional toll of that day was immeasurable, and we lost precious memories, personal belongings, and some of our vital documents. This began a cycle of instability, bouncing from one temporary situation to another, and it would be 2 years before I would have a place to call home again. This is one story of the thousands of Nevadans that face similar circumstances daily. As we face an ongoing housing crisis in Nevada, AB 283 represents a much-needed step toward creating a fairer and more just eviction process. I urge this committee to vote in favor of AB 283 and take meaningful steps to reform a system that has left too many Nevadans struggling to survive. Thank you.
Good morning, Chair and members of the committee. My name is Leticia, Leticia, Lopez, Lopez. I live in Senate District 11, Assembly District 8, and a proud leader with PLAN. I am also a single mother and full-time caregiver to my elderly disabled parent. I'm here to strongly support AB 283. I moved to Nevada in 1997 with my family to escape the crushing cost of living in California. Back then, Nevada meant opportunity and stability. But today, that promise is fading. Like many families, we're working harder than ever, juggling multiple jobs just to afford rent and groceries. AB 283 is not about giving tenants special treatment. It's about basic fairness. It ensures that people like me get a clear notice and a chance to respond before facing evictions. That's not just policy, it's dignity. It's the difference between staying housed or becoming homeless overnight. Please pass AB 283 for the mothers and caregivers and the families barely holding on. Thank you for your time.
Hello, my name is Jaira Mendez, YAJAIRA RIMENDES, and I am a proud member leader of Make the Road Nevada. Came here to fully support AB 283 summary eviction presented by Senator Carter. This bill, summary eviction presented for tenants in non-commercial properties, requiring the landlord to file first with the courts when requesting the eviction order. For tenants, this will make it clear and fair while having the court process. I live at my former residence for 2 years, and on November 26, 2023, I received an eviction letter saying that I had 28 hours to move due to the former landlord been having an illegal RV encampment. She had 8 RVs parked on the property, and the city as well as zoning issues in a residential lot. I was struggling with cancer and financially. I was also went to court and I won the case. I had only 2 days to pack up my RV and move into a residential area where the new landlord had proper documents to have an RV parking. I struggled with money as well with food. It was and also as well the high skyrocketing medical bills. It was either paying for food or rent. Right now, Make the Road Nevada has given me resources to help able to move to my new RV. I am now have a safe, stable, and secure place to call a home. Thank you.
Thank you, and right now I need to move to the phones. AVN, please turn on the phones.
If you would like to testify in support of Assembly Bill 283, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 283, please press star 9 now.
Hello, members of the committee. My name is Paula Luna. That's PAULALUNA. I'm the Deputy Director of Battle-Born Progress, and we would like to testify in support of this bill and ditto everything that's been stated before us. Thank you so much.
Thank you. Next caller.
Good morning. This is Connie McMullen. I'm representing the Senior Coalition of Washoe County. My last name, I'm sorry, is McMullen. First name is Connie. Both gentlemen came before us that we're presenting today through our Senior Coalition, and we unanimously support Assembly Bill 201 on behalf of our seniors living in the state of Nevada, especially the disadvantaged who can't drive or can't afford resources to deal with this kind of situation. Thank you so much for bringing it, and we would appreciate your support. Thank you.
Thank you so much. Next caller.
Hello, my name is Andy O'Connor, ANDYOCONNOR, and I would like to ditto all previous comments in support of AB 283. Thank you.
Thank you. Next caller.
Happy Wednesday, Madam Chair and Vice Chair and member of the committee. This is Dora Martinez representing the Nevada Disability Peer Action Coalition, and we wholeheartedly support this bill. And just FYI, people with disability, they have 30 days. Please go through the Nevada Disability Advocacy Law Center. Thank you so much.
Thank you. Next caller.
Follow with the last three digits, 327. You are now unmuted and may begin.
Good morning, Chair and committee members. This is former Assemblywoman Clara Thomas, and that's THOMAS. I am in full support of AB 283. As a prior representative of District 17, I've sat in eviction court, and I believe that this bill right now is good governance, and I am strongly urging the committee, along with the upper house and the governor, to finally sign something that will give relief to our constituents in the great state of Nevada. I fully support AB 283. Thank you.
Thank you. Next caller.
Sarah, there are no other callers choosing to testify in support at this time.
Thank you. We have 4 minutes. Go.
Good morning. Sarah Evans, SARAEVANS. I'm with SEIU and ditto to everything.
My name is Emmy, Housing Justice Organizer of Make the Road Nevada. I am in support of AB 283 because this would allow tenants to have a more just and fair eviction process. Thank you for your time.
Good morning, Chair Miller and the member of the committee. My name is Jungmin Lee, JOUNGMINLEE for the record. I am a social work student at the UNR, and I am an internet plan. I'm here to express my strong support for AB 283. I've learned social work is about addressing and then dismantling the unfair social structure that cause marginalized population to suffer. Evictions unfairly impact low-income individuals, people of color, and families, especially those who are already face systematic barriers. AB 283 creates a fairer system for tenants by simplifying the process, ensuring the transparency, and giving them a chance to contest evictions. It also helps restore power to those often powerless in legal proceedings. So that I strongly support AB 283. Thank you.
Good morning, committee. My name is Drake Macon, DRAKEMACON. I'm a leader with Faith in Action, Las Vegas. I'm here in support of AB 283. Ditto to everything, but I'd like to add that we are our brother's keepers. People are hurting right now. They really need help. And I'm throwing myself to advocate for these people, that they just get this little relief, a little bit of time to get their situation in order before getting thrown out on the street. Thank you.
Good afternoon, chairs and members of the committee. My name is Doralia Medina, DORALIA MEDINA. For the record, I am a member of Make the Road Nevada, and I'm supporting the bill AB 283. I'm a mother of teenagers and adults, so I don't want my kids to go through all these things. And I'm supporting because it will strengthen tenant rights by ensuring a fair eviction proceeding. And thank you for your time.
Good morning. My name is Glenda Hairston, Hairston. I'm a proud member of Make the Road Nevada, and ditto to all comments before me. I am in full support of Bill AB 283. Thank you very much.
We're at 1 minute.
Good morning. My name is Asaki Hardy, Ahsaki Hardy. I represent SEIU. I sit on the e-board with SEIU, and the AB 283 has personally affected me moving here since 2014 and moving here for reasons of being cheaper than where I'm from, Massachusetts, and then coming here to Shock, where the rents have increasingly went up over the past 5 years since COVID, and now has personally affected me. I would like to testify in ditto of everybody else, but I say I was personally affected because I came home on the 6th because I didn't pay my rent on time after being, this personally affects me, after being changed from a 2-household income to a family household income, and I do work and have a great job, and it affected me personally because I had a 7-day notice to quit on my door when I returned from Boston on the 6th. And I don't think it's fair that this process, where like they mentioned earlier, that Massachusetts and other states don't have this quick process, and I had to come here and learn this process and be subject to this scrutiny, embarrassment, and trying to race down, again, taking a day off from work to the court to file a complaint on something that could have been just rectified with the payment, which it did, but I still had to make sure in order to save me and my place and my 5 children, I had to still file. So I support AB 283.
Thank you, and we are now over time, so I will, and I want to be very specific, there is no one who's walked into this room that was downstairs, is that correct? Okay, so anyone who has not had the opportunity to testify verbally in support, but supports the Assembly bill, please stand up. Are you standing up? Okay, 1, 2. Okay, so I see, please record 23, are we the same? 23 people here in the committee room in support. We also, excuse me, we have you counted. So count 23 people in support. You may sit down, thank you. We also had our LCB staff, and I say this just so you know that they are nonpartisan staff and have no position or persuasion on any measures we bring forward. Go downstairs into the overflow room and count how many people are in support because they are not able to testify. So in the room for Assembly Bill 201, there were an additional 16 people in support. And on this Assembly Bill 283, there's an additional 13 people in support. There is no one in opposition, no one in neutral. With that, we will move on to opposition testimony, starting here in Carson City.
Good morning, Madam Chair, members of the committee. For the record, John Sandy, here today representing the Nevada State Apartment Association. I have some prepared remarks that I'm going to skip. I will submit those to the record for you. This was a very lively discussion. It's very important to have. I think it's important to note that evictions are not good for anybody. Obviously, very traumatic to tenants, but it's not a pleasant process for landlords either. And I just wanted to note that I think that changing the process is not going to stop evictions from happening. The cause of evictions is the cost of housing. It's not the process in which you follow to ultimately go through an eviction process. So with that said, I wanted to talk about the process, and from what I can tell, about 1969 is the earliest I can see that the summary eviction process, as it's done in Nevada, was implemented. And I don't think it was landlord-friendly legislators that put this in, and I don't think that all of the legislative sessions past that were any less sympathetic to tenants. I think it was a process that they looked at balance. And what does the landlord give up through a summary eviction process? Well, they give up the ability to proceed after monetary damages. So essentially, when an eviction starts, however long that eviction takes, the landlord's never going to get money back from a tenant for that time if they proceed under the summary process. And so since as was mentioned, every state has a summary process. It's just how they go about doing it. And I think that, the legislature in 69 or maybe even before that, they looked at that and said, okay, since the only issue the only issue of fact here is whether the tenant did not pay his or her rent. In most cases, obviously there's a nuisance in others, but when we're talking about failure to pay rent, if the tenant hasn't paid rent, that's relatively easy to prove. So then the question is, does the tenant have a defense for not paying that rent? And that's why they put the affidavit, submitting the affidavit with court. If the tenant wants to contest that I didn't pay rent because I have a really good reason, then they can go to the court and they can have their day in court. And
Mr. Sandy,
yes, I'm sorry.
Thank you so much.
So if I could close, I think the
Your
judicial
2 minutes are
sorry.
up.
No,
Thank you.
Good morning, Madam Chair, members of the committee. Bill Brewer. I'm the Executive Director for Nevada Rural Housing. Our challenge with this proposed legislation is really technical in nature. As a housing authority dealing with federal programs, we're already under significant federal guidelines in terms of evicting tenants and those kinds of things. To overlay this process on top of those federal guidelines would make it even more complex, and in some cases would make it challenging for us to obey one or the other. And so that's our challenge with this legislation. I think if we could exempt the housing authorities, we could certainly get to neutral on that.
Good morning, Madam Chair and members of the committee. For the record, Mindy Elliott, M-E-N-D-Y, E-L-L-I-O-T-T. This morning, representing Southern Nevada Regional Housing Authority. Ditto to what Mr. Brewer said. I do want to thank Mr. Norman. We have been in conversation with him. We are planning a meeting as soon as tomorrow with all the attorneys to try to figure out how the housing authorities can work with this proposed legislation. So I thank you for your time this morning.
Thank you so much. Is there anyone else here in Carson City? All right, we'll move down to Las Vegas.
Good morning again. This is Azim Jessa, A-Z-I-M-J-E-S-S-A, and I represent the Nevada Realtors. And again, we're thankful to Assemblyman Carter, to Jonathan Norman, to continue to work with us on some language and some of our concerns. It's our position that summary evictions keep housing costs down. I know before everyone starts to laugh, housing is way more expensive than anybody in this room and that room wants to see. But having a more costly and longer eviction process will only make renting a home more difficult because of more stringent requirements. We've already seen it happen as some of the landlord-tenant regulations change over the last few years. Some of the requirements to rent a home have become significantly more difficult, like 2 or 3 times rent and higher credit scores and whatnot. My daughter's 18. She's going to definitely be a renter before she's a homeowner. And if the requirements are so difficult, my daughter's going to be living with me forever. And I don't know if I want that to happen. So, like John Sandy said, we need more supply. That is the one thing that is going to put some power back into the hands of tenants, because if they have the choice, they have the ability to move. If prices are lower, they'll have more ability to control their own fate and destiny there. We do have some additional concerns. We'll also submit our submitted comments up in Carson City. So thank you all for your time and for the opportunity to present this morning.
Thank you so much. Is there anyone else there in Las Vegas? All right, AVN, will you open up the lines for opposition testimony?
If you would like to testify in opposition to Assembly Bill 283, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition, please press star 9 now.
Hi, my name is Ron Ariel, for the record, A-R-Y-E-L.
I am opposed to this bill because, again, it will increase costs for landlords and rental agents, and therefore increase rents further when you try to micromanage landlords and in what they do with tenants. You end up with higher costs and therefore higher rents. The current situation in Nevada is more than adequate for tenants to address problems they may be having with landlords. And so the answer is more tenant education and more assistance to tenants in accessing the process, which is already fair, and as well as building more housing at different price points, which would involve changes to zoning. Get rid of single-family home zoning restrictions, and you'll see a lot more housing becoming available to tenants at different price points. So I'm absolutely opposed to this bill. Yes, it's bad for tenants and bad for landlords. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers choosing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone. Is there anyone in Las Vegas for neutral testimony? Not seeing anyone. AVN, please open the lines, please.
If you would like to testify neutral for Assembly Bill 283, please press *9 now to take your place in the queue. Again, if you would like to testify neutral for Assembly Bill 283, please press *9 now. Chair, there are no callers choosing to testify in neutral at this time.
Thank you so much. Then I will, we do have one final question from Vice Chair Marzola. So if Assembly Member could return to the table, please.
Thank you, Chair. Thank you, Assemblymember, for bringing this bill forward. I think you touched on this very quickly earlier, to where this bill was brought last session, and I believe it was AB 340, and we touched on it being vetoed by the governor. Do you know why it was vetoed, his explanation?
Yes, I do, and I apologize for the oversight of not reading that into the record. That was my intention. As you can hear, it's not been a good couple of days. So if, with the chair's permission, this is Max Carter for the record. I will read that in briefly. AB 340 would restructure Nevada's summary eviction process in a manner that would impose additional and unnecessary delays and costs on those seeking to remove individuals who unlawfully remain on their property after the termination of their lease. This bill would make our summary eviction process more time-consuming than our peer states and would create ambiguous threshold standards which could be ruled upon by a judge without any formal hearing, providing insufficient protections for Nevada property owners. Support for this bill makes Nevada an inhospitable environment for residential lessors. I cannot support it.
Follow up really quickly. Quickly, thank you, Chair. I appreciate you reading that into the record. And again, I want to say thank you for bringing this bill forward, because nothing in that veto message ever talks about the tenant, its rights, its protections, tenants becoming homeless. It doesn't talk about seniors or veterans. And so thank you again for being here, and thank you for your indulgence, Chair.
Thank you, Vice Chair, and thank you, Assemblyman. And with that, I will go ahead and close the hearing on Assembly Bill 283. Last on our agenda today is public comment. Just a reminder that public comment is not to speak toward any bills that we heard today, but to other issues that are under the purview of this committee. So is there anyone wishing to make public comment here in Carson City? Not seeing anyone? Is there anyone there in Las Vegas to make public comment? Also not seeing anyone. Broadcasting, will you open the lines?
If you would like to provide public comment, please press *9 now to take your place in the queue. Again, if you would like to provide public comment, please press *9 now. Chair, there are no callers choosing to provide public comment at this time.
Thank you so much. Then I will go ahead and close public comment. Thank you, everyone, that came to participate today. This is our favorite part, to hear directly from the public. Thank you, members, for your thoughtful, detailed questions and your brevity, because we are making floor now. So I want to remind members that we are going to quickly dash, so please give us an opportunity, because we don't want to hold up the rest of the day. Please give members an opportunity to quickly dash out of here and onto the floor directly. We will catch up with you. You may find us some other time. We're not leaving the building, but we need to get to floor. One more reminder is that we will not have Judiciary in the morning tomorrow. Judiciary, we will be joining the Senate at their time, which is 1 p.m. tomorrow afternoon. And we will be in 4100. So again, we will not meet in the morning. We will meet at 1 p.m. With that being said, we are adjourned. Thank you, everyone.